Hey guys, Christian here. Unfortunately, almost sweater weather. I wanted to make you aware of a Supreme Court argument that happened this week dealing with the Voting Rights Act of 1965. The case is Louisiana v. Callais. It's a very complicated case. It's actually a case that the Supreme Court already heard last term, but they didn't decide it. They actually left it unresolved and they ordered a re-argument. And when they order a re-argument, that means they want to go for broke. That usually means we couldn't decide this thing the first time around. Maybe there's some problems with this case. We need to go big or go broke. And this time they decided to actually do the thing. They decided to ask the question whether a remedy under the Voting Rights Act, Section 2 of the Voting Rights Act, violates the 14th and the 15th Amendment to the U.S. Constitution. Can you imagine that? That a law that Congress enacted decades ago to remedy discrimination against black voters, somehow a remedy under it violates the Constitution itself. And what happened here was that a group of white voters sued because they were unhappy with the way Louisiana created this new congressional map. In fact, created this district that helped to remedy a prior violation of Section 2 of the Voting Rights Act. And in doing that, they created a district that, in fact, allowed black voters to elect the candidate of their choice. I heard the argument. It was more than 2.5 hours, which is insane for a normal argument. I may be going crazy, but I listened to the whole thing, and never once in the whole argument did I find even an inkling of the so-called originalist justices trying to do an analysis of whether the original meaning of the 14th and the 15th Amendment as applied to black voters violates the Constitution. Can you imagine that a district created in order to remedy prior discrimination against them because Louisiana was diluting their voting power, somehow that remedy violates the Constitution? It boggles the mind. And what boggles the mind even more is that, try as you may, I couldn't find even an attempt to analyze what the text of the Constitution, namely the 14th and 15th Amendment, somehow allows this court to invalidate the remedy of that violation. It's almost like the world upside down. I joked on social media that this case boils down to a single sentence. The only way to stop discrimination against black voters is to stop discriminating against white voters who complain about that initial violation that was remedied. Because that's what this case is about. And if the court finds that that remedy is unlawful, then all bets are off. And the reality is that that's going to make it even harder for black people, not just in Louisiana, but in many other parts of the country, especially in the South, to elect candidates of their choice. And that means bad news for voting rights. Peace out.